Hi folks, Lee Pacchia here, and you're watching The Business of Law, where we talk about the challenges and the opportunities facing today's legal profession. We're joined now by Mark Cohen. He's the founder and CEO of Legal Mosaic and writer at Legal Mosaic, Bloomberg BNA, and Mimesis Law. Mark, good to see you. Welcome.
Good to be here, Lee. Thanks.
So we're talking about Dentons today, and this is a really, really interesting situation. They're facing a significant malpractice claim. I don't want to overstate it. The money involved here isn't exactly world-shattering, but as you wrote on Mimesis Law a couple days ago, this is a situation that brings up a lot of serious questions about the Swiss Verein model for law firms, at least when it's done at the type of scale that Dentons is currently undertaking. Let's start with the basics here. What is this case about?
Well, Lee, I think the real basis of the case involves a garden variety conflict situation that Dentons apparently got itself into. It was involved with a patent prosecution on the plaintiff's side. That's the good news. The bad news is that it was adverse to a longtime client of the firms, Dentons, and its predecessor firms, and that client was the Gap. The factual situation, frankly, could scarcely be worse. Dentons allegedly did not provide notice of the conflict to its client. It secured litigation financing, disclosing the conflict to the litigation financier, but again, not to the client. And it had several opportunities prior to the motion to disqualify them, which is really I think, the crux of the whole situation. Multiple opportunities to resolve the matter, and incredibly did not. So that's the big deal. As you point out, it's not so much the legal malpractice action, which does not, by most accounts, involve a huge amount of money, but rather the disqualification and the harsh light it seems to shed on the Swiss Verein structure that Dentons thought it would be able to utilize to effectively immunize itself from conflicts that would be, I think, problematic for any law firm.
So let's unpack what's happening here. Why is the Swiss Verein of particular interest in this story?
Well, first, Dentons, like several of the largest law firms in the world, is a Swiss Verein. And a Swiss Verein is just a fancy name for a type of governance structure where essentially Swiss Vereins mean this. There's a unified brand under which all of the so-called member firms within the Verein practice. So in Dentons, the name is Dentons. It could equally apply to DLA, to Hogan's Label, or to a number of other very large firms that are Swiss Vereins. Each Verein member has its own P&L. Each Verein member, in legal terms, would be juridically independent. However, one of the fundamental premises that has fueled the extraordinary growth, particularly of Dentons, is the fact that the firm believed that structuring itself as a Verein, if conflicts such as the one that we're talking about here today were to arise between different members within the Verein, that would not necessarily mean that the firm could not undertake those kinds of representations on the theory that each of the member firms was separate and apart and had its own P&L. That's what this situation is really about.
So if Dentons loses this case, what happens?
Well, I don't want to read too far into what it means for Vereins generally, because there are some subtle differences between and among different Vereins, particularly with respect to the way different partner members are structured and treat each other. However, I think for Dentons, it could be potentially disastrous. And I think at the very least, it would cast a pall upon other firms that have Swiss Verein structures and may or may not have responded similarly to the way Dentons has in this particular case.
I mean, we're talking about the firm here, Dentons, that has just undertaken this incredible growth strategy through acquisition and merger over the last couple of years. If this case goes the wrong way for Dentons, is this going to slow its growth?
Oh, I think very definitely it's going to slow its growth. And I think equally importantly, already it's going to be casting some doubt in the mind's eye of certain clients in terms of sort of what sort of management structure would allow this kind of a problem to get as far as it has. And number two, is the firm perhaps taking an approach which is at best, shall we say, somewhat cavalier, and at worst, just wholly indifferent, to certain conflict rules. As I say, the facts of this case, as recited by the judge whose opinion now is the focus, Chief Judge Bullock for the International Trade Commission court, which, by the way, functions as an administrative court. The facts as recited in his scathing opinion could scarcely be worse to Dentons.
Conflict rules and Swiss Vereins structure, not really something that I'll admit I've thought about a whole lot over the past couple of years. Is this an area that should be under greater focus?
I think clearly this case is going to put that in much greater focus. And interestingly, there's a lot of misunderstanding, Lee, in terms of the difference between Vereins and, other types of legal or law firm networks. That might be something worth, delving into for a moment, but I leave.
Yeah, well, what are those differences? Let's unpack that.
Sure. So basically what you've got is this. Vereins are generally single branded networks. So, for example, all the member firms, let's back up for a second. Dentons itself, as other large Swiss Verein law firms, is a network. That network is comprised of numerous law firms. But in the case of Dentons and other Swiss Verein firms, as I said earlier, they are all practicing under a single unified global brand. And that, by the way, is what the Judge Bullock's opinion hoisted Dentons on its petard, basically saying you can't have it both ways. If you are going to present yourself to the public, as Dentons does, as a unified global firm, then you can't hide behind the Verein structure for conflict purposes. That's what the case is about. Going back to your question about the difference between Vereins and other networks, there are about 170 other law firm networks that exist around the world. And if you were to put them all together, they would comprise an enormous percentage of market share for law firms. But unlike Dentons or other Swiss Vereins, these other networks are networks of independent law firms, meaning that the different member firms, each, like Vereins, retain their independence, retain independent profits and loss, but significantly different from Dentons and the other Swiss Vereins. These firms are not going to have the same sort of conflict problem that Dentons finds itself in because they are not branding themselves as a unified firm, and so can really, maintain an independence that Dentons is now going to have a difficult time maintaining.
Looking down the road here, do you see regulators perhaps being tempted to act in light of this case?
Well, I think this case definitely raises some very serious questions in terms of the Swiss Verein, and particularly with respect to how it operates with respect to conflicts. Conflicts, as you know, Lee, are the bane of any law firm's existence. And the larger a law firm becomes, the more conflicts are going to become an issue. It's the principal reason why a lot of law firm mergers do not come about, because there would be material conflicts between or among different clients that militate against a merger. But in the case of Dentons, they've merged or acquired firms with just breathtaking speed on the assumption, which may prove to be false, that they are, by their Vereins structure, somehow immunized from the kinds of conflicts that other law firms have to deal with. And again, if this thing goes south for them, it's going to have, I think, serious issues, not only for their structure, but also for other Swiss Vereins.
Yeah, we're talking about a firm here that's expanded at a pace that's almost Napoleonic in scale and speed. One has to wonder, is this event their Waterloo?
Well, it very well could be, and I will tell you this, Lee, that in terms of Dentons, and I think many people share my view, have thought for a while that they really are acting more as a law firm version of a roll-up than anything else. It's fine, in other industries, but law, as you know, has unique sets of rules that govern the conduct of lawyers, and conflicts are one in particular that perhaps Dentons might have wanted to pay slightly closer attention to, particularly in terms of having the ability to kind of bypass this very public airing of this issue. I think that that's another issue, is why did they let it get so far down the road?
Conflicts are tough. Mark, always a pleasure. Thank you, sir.
Great to be with you, Lee.
That's Mark Cohen from Legal Mosaic. If you'd like to see more of the stuff we're working on, be sure to check us out online. You can find us at mimesislaw.com. We're also on Facebook, LinkedIn, and Twitter. I'm Lee Pacchia. Thanks for watching. See you next time.
With the caveat, Lee, that this is speculation, but I've heard it from 3 or 4 what I would call fairly well-informed, highly placed, and reliable sources. They're telling me that this was perhaps not so much a hack as it was a disgruntled mistress of a partner at the law firm